and it's settlement time. And they're asking you to cut your bill by 50%. And you say, hey, you know, you're asking me to make a business decision. I have to make business decisions based on data. Can you show me the disbursement sheet? I want to know what the final settlement was, because I need to know if I'm being treated fairly. Are you taking a cut? Or all the other providers taking a cut? I can't make this business decision without that information. So what these attorneys will do is they may bully you and say, well, I can't do that. It violates attorney-client privilege, which is true. So how do you combat that? You combat it with a good AOB, an assignment of benefit sheet. And you may have an assignment of benefit sheet, but it might be missing a few things. So I'm going to share my screen and cover an AOB. So, and this is the strongest AOB that I've found. I'm going to cover some of the points, and I'm just going to go over those with you. And because I want you to make sure that your AOB covers these specific topics. So this is the first page. So this is what you're giving your patient, right? By the way, you're not treating the attorney. The attorney doesn't owe you any money. The patient owes the money. So it doesn't matter what forms your attorney will sign, won't sign, doesn't matter. He won't sign your lien. He won't sign your letter of protection. That's okay. You're going to lock up the patient. So what you're doing here is you're explaining to the patient, we're going to extend you some credit. We're going to treat you, we're going to generate a bill, and you don't have to pay anything. But you're going to assign the benefits to us at the end of this case. So there's a paragraph in here in consideration for this office providing services to you. Because I don't have sufficient funds, I being the patient, I hereby seek credit and grant a lien to this office against proceeds, something like that. I authorize and direct my attorney to sign any letters of protection from this office. I understand that failure of the attorney to sign a document, this clinic does not release the attorney's responsibility to honor this agreement. Boom. I direct my attorney, insurance company, or claims adjuster to pay outstanding bills directly to this office. Okay. I have chosen not, this is again, this is the patient's words. I have chosen not to use my health insurance that I may have available for services rendered. Choosing this option means that the attorney, claims adjuster, insurance company, MedPay benefits, or yourself will pay for service. And this is how you're going to lock your patient up. You're having them sign a personal guarantee and a lien that any proceeds have to be paid from any settlement, judgment, or verdict. Okay, even if it doesn't settle, the debt is still due. Okay, so just some highlights of this AOB, but I'm not done. It's page 2. So here you're authorizing to send your records to the attorney, and you're protecting their privacy. And you're authorizing, the patient's authorizing you to give copies of any records, reports concerning any condition in the past. All right, you get it. Informed consent and release of liability. Let's see. Talking about you're letting the doctor do all the services and modalities that the patient needs for present and future care. Let me see this. This is a good one. All right, this is a good paragraph here, because here is really the assignment of benefits. You're requesting the insurance company, the attorney, to pay proceeds directly to you, the provider. And let me clear this. You agree that this office, meaning your office, be given power of attorney to endorse any and all drafts for payment of my bill. So even if they make out the check, the insurance company, they'll do a scumbag move and address it to the patient and you have power of attorney. You don't need to chase down the patient to sign the check. Okay, so this is a strong AOB that the patient is signing, giving the patient, instructing the attorney to be transparent with you. They signed over power of attorney. So that's what I wanted to cover, to stop being bullied. Now, I'm going to go a little deeper. Let's say an attorney pulls some kind of crap and tells you, we never received it. You may have emailed it, but we never received it. Okay, so let me show you this. I am going to show you my email platform, my Gmail. Okay, so I have a little software I've installed. It's about $15 a month. It's called Yesware. And what Yesware does, it goes right into Google Chrome in my Gmail. It also works with Outlook. There's Gmail. You can get HIPAA compliant Gmail, HIPAA compliant Outlook. But I installed Yesware on here. Well, what is Yesware? Well, Yesware will tell me when I send an email, if it was opened or not opened. So right here, Monday, July 25th at 5:37, or I'm sorry. I sent this email to this doctor July 25th at 5:30 p.m. I'm going to click on it. I know that he opened it at 5:37, and you see this little orange. I can tell Yesware to let me know if they viewed the attachment. So I sent my AOB to this doctor, and I sent it as an attachment, and I told Yesware to let me know if they opened the attachment. And this guy lives in Texas. It even told me where it was opened. He also opened it again the next day, 10:35, 9:21, and viewed the document again on 9:22 p.m. So this is where you can hold the attorney accountable and prevent him from pulling the wool over your eyes that I never received it. I don't have that. Doesn't matter. Now you have documented evidence that they did get your email, they did open it, and they did open your attachment. Okay, so Yesware is a great little software, a little sneaky, to let you know if attorneys or anybody open your emails and if they open the attachment. Okay, so I'm going to tell you a little story here. We're going to end it. And if you have any questions, I'll check Facebook about this presentation and about not being bullied. I'm here to help you. So feel free to ask a question underneath, in the comment section. So what's up, Greg? I'm glad you're here. So here's what I'm going to show you. I had a client, doctor. He was in settlement negotiations, and the lawyer said, you know what? We never got your bills. We never got your stuff. We just don't have it. And it's already been settled. The funds have been dispersed, and there's nothing that I can do. But let me do this. I'll send you 2 more clients this week to make up for it. Well, this doctor had enough. And he said, you know what? I'm not going to do that. I don't want any more clients from your office. I'm not looking to do twice the work for half the pay. So I'm going to read an email that he sent to the doctor, and you're going to love this. Okay. Again, the attorney said, sorry, I never got your bills. Funds have been dispersed. Too bad, so sad. Well, this is the email I helped this doctor craft to send to this attorney. I'm writing to you in hope of resolving an outstanding balance. My office has sent an email containing the final ledger and balance owed regarding your client, our patient, Mrs. Blank, upon the request of Mr. Attorney, which was ignored. A copy of the email sent to Mr. Attorney is included. As you may or may not know, our office treated Ms. Blank under a letter of protection. My total bills were $78.55. In March, I received a return phone call from Mr. Attorney regarding this matter, who admitted that he had not opened the requested email and therefore did not include my bill for services in the final statement for Mrs. Blank. Monies were paid out and my bill was not considered and satisfied. After several phone calls back and forth, Mr. Attorney became irate, condescending, and arrogant, told me that the funds had already been dispersed and that there was nothing he could do. Now, this happened in Florida. And I'm not done. So American Bar Rule 1.15, I want you to read American Bar Rule 1.15. It has to do with safekeeping of records and being transparent if a third party has interest in property of the case. The property in the case is your bill. So it's Rule 1.15, safekeeping of records. So he copied it here. According to the bar, notice of receipt of trust funds, delivery, accounting. On receiving funds or other property in which a client or third person has an interest, the third person is you as the doctor, a lawyer must promptly notify the client or third person. Except as stated in this rule or otherwise permitted by law or by agreement with the client, a lawyer must promptly deliver to the client or third person any funds or other property that the client or third person is entitled to receive, and on request by the client or third person, must promptly render a full accounting regarding the property. So Google, go to your state bar website, Google safekeeping of property and accounting of a third party, and you'll come up with their bar rule. The state bar does not like attorneys that break the bar rules. So let me continue. So he put that bar rule in the letter. Given the admission from Mr. Attorney that he requested our ledger and bills by email, however, failed to open the email, also considering that Mr. Attorney told me that it was completely his fault and that my bills are left out of the final disbursement, I expect my bills to be paid in full. The time for negotiations is over. Here's the paragraph that I love, and you're going to love it too. If I do not receive a check for the full amount of $78.55 in my office delivered by mail or courier by Monday, December so-and-so, I will assume that you prefer not to honor my bills for services rendered, and I will be left with no other choice than to file multiple complaints of the bar, naming you, Mr. Attorney, Partner A, Partner B, and Partner C over your conduct. I will also consider filing a criminal complaint for theft by conversion. Respectfully, Dr. Chiropractor. 3 days later, a courier delivered a check 3 days later in his office for $78.55, not zero. Stop being bullied by these attorneys. Get a good AOB. If you want mine, reach out to me. I'm happy to share it with you. And stop getting bullied by these attorneys. All right. So I hope you enjoyed that and understand that it's the patient's responsibility, and you don't have to be bullied by these attorneys anymore. Okay, so if you have any questions about that, now obviously that's going to ruin the relationship with the attorney, but this doctor had already decided, I don't want any more of your clients. You guys don't pay. I'm done with you. I don't want a relationship with you. The time for negotiations is over. Even though they promise him, oh, we'll give you 2 more, 3 more. I don't want to deal with you. I want to go find reputable attorneys that are not greedy, that follow the bar rules, and that I enjoy working with. You don't have to work with these assholes anymore, because there are just so many attorneys out there that are looking for doctors all over your state. And if you sit there on the sidelines and continue to do nothing, you will not grow your personal injury practice. 30 minutes a day, organically, for free, is all you need to grow your personal injury practice. So what I want to offer you today, here's the call to action. If you want to learn a little more, if you want to ask me some questions or talk about my program to help you get personal injury patients by working side by side with me, to help you get a social media strategy, hire a marketing liaison and train them and track them, and help you with your communications with attorneys, type strong in the comments below. Type strong, I'll reach out to you. We'll set up a 15-minute phone call, understand what your goals are. I'll ask you about where you currently are in personal injury, how many new patients you're getting per month, where you want to be in the next 30, 60, 90 days. Let's learn your goals and let's see if we're a good fit. And I'll invite you and share my program with you and see if we're a good fit to work together. So just type, what did I say, strong in the comments below. And let's get some more personal injury patients. So I want to thank everyone for staying till the end. Hope you're having a great week. We're going to be back here next Thursday, 4 p.m. Eastern. I'm here live in this Facebook group at 4 p.m. Eastern every single Thursday to help you grow your personal injury practice. So type strong in the comments below. I'll reach out to you. We'll get on a chat and let's see if we can grow your personal injury business together. Okay? Doctors, have an awesome day, and I'll see you next Thursday right here in the Facebook group.